Disney World restaurant is sued after a woman with severe allergies dies. Can a restaurant in Canada be sued for negligence in that regard? We'll find out coming up on the iHeartRadio Talk Network. Good to have you along. So some people have an allergy, and it can be very severe, to nuts, dairy products, that kind of thing, and becomes a real problem when they go to restaurants. So here's a horrible story out of Florida, and it's a Disney story. Couple went to the restaurant. The wife is actually a doctor, and she has severe allergies to both nuts and dairy, and she made sure that the waiter knew that. She said she required allergen-free food. Were they able to do that? How about this item or that item? And the waiter went and checked with the chef, came back and said, you can order this, this, and this, and you'll be fine. The food arrived. She was a little suspicious. The waiter then guaranteed that it was not a problem. She ate the food. 45 minutes later, she's a doctor, she administered her own EpiPen. She died anyway. Now her husband is suing Walt Disney Parks and Resorts for negligent. It's only a $50,000 suit. You know, you think about some of these things, especially in the United States. I want $800 billion. And it may be that Jeffrey Piccolo, who lost his wife, he's looking at this and saying, I don't need the money. I just need to get Disney's attention. What would happen here in Canada in a circumstance like that? How responsible are the restaurants to a customer that has severe problems? Joining me on this, Nainesh Kotak, founder of Kotak Personal Injury Law. Good morning.
Good morning, Jerry. Thanks for having me.
First of all, and you're practicing here in Canada, not in the U.S., but do you think he's going to win that suit against Disney?
I think he has a really good shot at it. And also with respect to the damages, there's just a clause they have in statutes there. So it's in excess of $50,000 in addition to income loss. So I suspect the award actually could be quite large, looking at the potential income that she was making. I think she was in New York as a New York doctor.
Right.
If the facts that are being alleged are true, that the waiter was aware of it, talked to the chefs, came back, guaranteed that it was allergy-free in her circumstance, I think they're in for a whole heap of trouble. Things are a bit different here in Canada in terms of what we get in terms of awards, and likely here in terms of the standard of care as well, Jerry. So couple of things. The cases we've seen in Canada, there's one in Saskatchewan, I think BC and Quebec, but the Quebec, we will look at their laws over here in Ontario. There is, first of all, we got to establish that the restaurant has what's called a duty of care. And they do have a duty of care to patrons, obviously. But that there was negligence, and the negligence resulted in the damage to the person. So far, Jerry, in Canada, the onus has been on the individual with the allergy to make it known they have a particular allergy, to alert the staff.
Right.
That may change down the road, though, as awareness starts to get more. And you go to most restaurants, they actually ask you this question anyway, right? They do tend to ask you. But so far, the case law seems to be, they need to know that you had the allergy, and you made them aware, and nevertheless, they still went ahead and served you food that had the items that you said you couldn't eat.
Yeah, well, I can tell you, I have a son, many listeners know, and maybe they think I talk about it too much, but I have a son who has a restaurant in Dallas, and the way he handles it is, are you nut-free? No. Are you dairy-free? No. Do you have gluten-free products? No. So he just lets them know, I'm not taking any responsibility for that sort of thing.
That's one way to do it. I've been to Dallas many times there. My sister usually lives. I love the restaurants there. I should check his place out next time I go. But the reality is, I saw an article in the Globe and Mail today, 7.5% of Canadians are affected by food allergies. So if you're going to take that approach, that we don't give a damn, we're going to put a sign up that we're not, no, we're not this, no, we're not this, not, you might lose customers. It might not be, in fact, a good business model, right?
No, wait a minute. He doesn't put a sign up. It's just if you ask,
okay.
They'll say, no, I'm sorry, we're not a large enough kitchen to separate all of that out, and we could have, something leak over to another product. He's not going to do what that waiter at Disney did, where they said, we guarantee you that it's, no, he's not going to do that.
Yeah, I guess then, he's not putting himself out there for a potential claim. I don't know, again, business practices, right? If that would work so well in Canada, we got a different, way of looking at things, it seems. So I'm not sure how well that would do in a business model here. But I think over time, Jerry, I think the onus is actually going to shift to the restaurant to with healthcare training and, chef training and all that. I think that eventually you will see case law where it becomes sort of an onus on the restaurant to ask if you have the basic allergies. There might be some things that are so rare that they couldn't possibly be aware of. But right now, the way the law is, according to the case law that we have, the person, the customer needs to make the restaurant aware that they have a particular allergy. And then, as it may be, if the restaurant says, sorry, we're small, we can't accommodate that, well, then the customer has a choice to leave, right? They don't have to eat the food. But if you tell the restaurant you have this allergy, they go, oh, yeah, it's okay, fine, go to the kitchen and come back, you get served, and then as a result, you suffer injury. I think that becomes a serious problem for the restaurant because they have a duty of care and they were negligent because they were aware of what you were allergic to.
What we're talking about here with Nainesh Kotak, founder of Kotak Personal Injury Law, it comes from a lawsuit that's been filed against Disney in Florida, where a woman who had severe allergies made the restaurant aware of that. They guaranteed her that the food was okay. And 45 minutes after she left the restaurant, despite the fact that she's a doctor and she administered her own EpiPen, she died. And it may well be that the lawsuit will be successful against Disney. I can't see, if all of these allegations are true, Nainesh, that Disney will have an argument to make. You can't guarantee your customers of something like that. But at the same time, I don't want 100% of the onus to be on the restaurant. I mean, because you also have this circumstance. People will come into a restaurant. Well, I have to have gluten-free. Do you have gluten-free on the menu? We really don't. I'm sorry. And then they sit there and look at the menu and order stuff that has gluten in it. So there's quite a number of people who it's just notional. It's not, they don't have the problem that woman had.
Yeah, I absolutely agree. The stats I sort of talked to you about, 7.5% of Canadians are affected by food allergies. How many of those are actually serious enough that the person would suffer significant injury if they ate that product? How many are not really diagnosed? It's the individual themselves saying they have this allergy and it's sort of it doesn't necessarily, it's not medically shown. But that's not really what we're talking about here. We're talking about potential negligence on restaurants. And I think in Canada, again, it's incumbent on the customer to alert the restaurant to their allergy. And if the restaurant then goes and makes suggestions after that or doesn't warn them, hey, we can't do it, I think that the restaurant could be found liable for injury the person sustains, having an allergic reaction to the allergy that they actually told the restaurant about.
Somebody just responded here to the conversation I had with you there about how my son is handling it. And Vito writes in, maybe it's less of a headache if you lose a customer.
Yeah, it could be. But again, we're a little different in Canada and the United States. You're going to get a social media post out there, an Instagram post, hey, that restaurant did this, did that. Unfortunately, reputation becomes a problem, so that it's not just one customer who won't come back. You might have other ones as well, right? So, unfortunate for business owners, they have to deal with some of these types of issues as well, in terms of what happens after an interaction with a customer.
All right. But, I'm going to be a little blunt here, despite the fact that I very much appreciate your expertise here as a personal injury lawyer. But some of this comes from, let's sue anybody we can. And then let's make that third party, which is the restaurant, responsible for the customer's actual problem.
If that was the case, lawyers won't be in business. We would lose so much money on frivolous cases. I know myself and most competent lawyers do not take cases unless there's real damage to a person and there's a viable case, right? So I don't think it's a case of, hey, let's invent a lawsuit here. You want to take cases obviously where there's a legitimate concern over negligence and where there's significant damage to a person. Otherwise, it's just not worth taking those cases.
All right. Nainesh Kotak is the founder of Kotak Personal Injury Law. I appreciate it. Thank you very much.
Thank you.
Another lawyer will join me coming up in a moment. It's Lawyer